So I think we should start now. I see we have a lot of resident experts in ethics here. Happy hump day, everyone. Good evening and welcome to this New York City Lera chapter program on ethical considerations in arbitration. My name, as a lot of you know, is Sudip Mukherjee. I'm the New York City Lera chapter vice president this year, and I'm senior associate counsel with Local 1199 SEIU United Healthcare Workers East. Our topic today, as I said, is ethical considerations in arbitration. So this panel will be discussing frequent ethical issues that arise in labor and employment arbitration and take an in-depth look at the Code of Professional Responsibility and some recent advisory opinions that affect ethical obligations on arbitrators and attorneys. It's just I need to get some housekeeping out of the way for our CLE written materials, evaluation forms, and affirmation forms have been emailed to all those that have registered for this virtual program and interested in CLE credit. 2 attendance verification codes will be announced during this program. Please record the 2 attendance verification codes announced on the affirmation form that was provided. And please complete and return the form to cle@ebglaw.com in line with instructions at the bottom of the form. And I'd like to thank Epstein, Becker, and Green as well for sponsoring the CLE program. And the instructions should be on the form that I sent. And I'm actually going to put myself on a timer that I just recalled so that I'll remember to announce the code. Please note that due to the upcoming holidays, CLE credit will not be processed until mid-January. With no further ado, I think I'm going to ask the panelists first to give us a short introduction, their practice and experience, and then we can start the program. I'll start with a resident expert, Robert L. Douglas.
Thanks, Sudip. It really is a pleasure to be here tonight to see so many familiar faces. Before I do the little bio type of thing, I just want to make it very, very clear at the outset. I'm only speaking for myself. I'm not speaking for the National Academy of Arbitrators, the AAA, the FMCS, Lera, anyone else you can think of. I have the backdrop because I think it's $500 or $600 a year to be a member of the National Academy of Arbitrators, and this is a tangible benefit of belonging to the Academy. I'm a full-time arbitrator, mediator, private and public sector. The years have added up. I think I started in 1981 or so when Dick Adelman was still an advocate. He actually appeared before me. I don't know if you like the result, but that's a different story. I served as assistant dean at Hofstra Law School for 10 years and taught there for 12. Worked for the NLRB out of law school. And that's what I do. I've also
NPR News. I'm Joseph.
I'm sorry, I didn't hear what it was, but whatever it is. So let me just start out with this. The way we're going to do this is I'm going to give a very, very brief overview of the Code of Professional Responsibility for Arbitrators of Labor Management Disputes. We want to encourage you to ask us questions. Mary Ellen will be providing the employer perspective. Sudip will provide the union perspective. But please, in the chat, feel free to pose any questions that you have, and we will do the best we possibly can to provide appropriate responses. I came up with the notion on Monday that the way we should really start this evening's program is to pose a riddle. And the riddle is, how is the Code of Professional Responsibility like a parachute? And I think the answer is, it's only helpful if it's opened. And what we've discovered over the years in doing surveys and questioning people at these types of presentations is most people have never really studied the code. most people may not have read the code in a long time, if ever. And so you have these wonderful advocates who appear in arbitrations on a regular basis, and they don't know the principles that are embodied in the code that can oftentimes be very helpful. So what we're going to do now is I've already set it up, and we're going to do a screen share so that you can see the material that we're focusing in on as we're going along. And if Sudip and Mary Ellen, if you can just give me a thumbs up so I know that everybody has the screen share. Okay, good. So you'll notice from the table of contents, and that's what I want to go over first. The code is divided into 6 different parts. I always used to say that the first 3 parts are the arbitrator's responsibility to the profession, to the parties, and to administrative agencies. And for whatever reason, I don't think I emphasized enough that the initial part is the arbitrator's qualifications. And so I think it's very important to underscore that the qualifications of the arbitrator are covered in part 1 of the code. We then segue to part 2, having to do with the responsibilities to the parties. And then you'll see as we scroll down, responsibilities to administrative agencies, pre-hearing conduct, hearing conduct, and post-hearing conduct. And so that's the basic structure. And there are an awful lot of answers that are provided in the code that can be very helpful to practitioners and, of course, to arbitrators as well. The explanatory information that sometimes can be very helpful involves advisory opinions. And we're going to go over advisory opinions 24, 25, and 26 as we go forward. But remember that the advisory opinions can be very, very helpful. For example, advisory opinion 26 relates to virtual hearings. And Mary Ellen and Sudip and I have agreed in advance that when possible, we're going to try to incorporate any new challenges that may exist with respect to virtual hearings into our discussion. So that's the approach that we're going to take. And with respect to part 1 of the code, you'll notice under A, the general qualifications, that we get into this whole issue of impartiality. And the ultimate question is, what does it mean to be impartial? When you speak to advocates, they're happy to say that they're looking for an impartial arbitrator, but you know that underneath it all, they want someone who's impartial in their favor. And so this notion of impartiality is difficult to define. The analogy to an umpire behind home plate in a baseball game is pretty good in the sense that the umpire doesn't have a predisposition, presumably, about whether a particular pitch is going to be a ball or a strike, nor should an arbitrator have prejudged the nature of the case until the record is closed. And I think that's one thing that is very important, this notion of keeping an open mind, because a party makes an opening statement, the other party may either make the statement or reserve until the first party has presented its case. And is it ethical for an arbitrator, while hearing the first party's presentation, to start forming an opinion? Because then it's really shifted the burden of proof, because the first party going forward presumably has the burden of proof. But then if you've already made up your mind, how can the second party overcome that? It puts a greater burden on the second party. And so trying to develop the skill set from the neutral standpoint to maintain the open mind sometimes is difficult, because you're already hearing testimony, you're absorbing it, and therefore you could have a conversation about whether, from an advocacy standpoint, not necessarily an ethical standpoint, if the advocate who will appear second ought to be making an opening statement, at least of some sort, so that the neutral is in fact able to maintain the open mind, the impartiality. Now, when we get to this notion of placement on a roster, of course, for many new arbitrators, the challenge is just to get on a roster, whether it's AAA, FMCS, NMB, New York State PERB, Jersey PERC, whatever it happens to be. But of course, we know that that doesn't guarantee that the person is going to be used in any manner. So let's talk a little bit about the proverbial issue of splitting the baby. And I think at this point, Sudip and Mary Ellen, maybe you can share from an advocacy standpoint, this notion of splitting the baby and how you react to it if and when you perceive something like that is taking place.
Mary Ellen, why don't you go first and introduce yourself as well?
Thank you, Sudip. Many of you I know, I'm Mary Ellen Donnelly, formerly with Putney Twomley, currently with Bond, Schoenick and King, management attorney, been doing arbitrations and labor relations for longer than I want to admit at this point. So that means a long time, longer than Sudip, I learned today. So I'm very happy to be here. Thank you all. And actually, Sudip and I spoke this morning about our opinions on splitting the baby, which can be at times incredibly frustrating from both our perspectives. And I will let him speak about his. But if I have a case where the grievant is clearly wrong, whether it's disciplinary or discharge, and the solution is put them back, no back pay, sometimes just because of length of employment, that is frustrating to have a result that's not the correct result, in my opinion. And believe me, we all know when we have bad cases, we all know when we're going to lose sometimes, but it's a difficult pill to swallow if the person's really a bad actor. They've engaged in conduct that is violation of the CBA, the policies, sometimes the law, and the solution is put them back, no back pay, or reduce the suspension to a written warning. Not my favorite thing.
Sudip, you're on mute. There you go.
Yeah, sure. Yeah, Mary Ellen and I discussed this, and we agreed that we both don't like splitting the baby. And from my perspective, everyone loses. In particular, so if you have a poor case, from the union's perspective, say it's a discharge case, and the person probably deserves to be discharged. Progressive discipline has been followed. This is someone who maybe is not, the progressive discipline is followed, and maybe discharge should be the next progressive disciplinary step, but the arbitrator gives one last time-served suspension and returns the person to work, thinking that the union's going to be happy with that. And depending on the case, they might be, but what happens is long-term, what happens is the union will, in the end, if you're splitting the baby like that, what ends up happening is the union might as well bring poor cases to arbitration, and they know that the arbitrator is going to split the baby and get that person their job back. On the other hand, if you have a good case, where this person deserves to be not only reinstated, but be made whole in all respects. But, and I know from experience, some arbitrators like to split the baby, and splits the baby to keep management happy to a certain extent, and says, well, the union should be happy because this person was reinstated. I think that's just the wrong decision, because the grievant didn't do anything wrong in this matter. There was no just cause for termination. Why should the baby be split just to keep the parties happy? That's more, I feel, an arbitrator would do that to keep the both sides happy, so the arbitrator would be chosen for the next case, practically speaking. But I don't think it's a good decision for the employer or the union long term.
I think it's important to point out that there may be situations where a reinstatement without back pay is not splitting the baby, but acknowledges that neither side is blameless. And there may be situations, and one of the concerns as a neutral is you don't want to appear that you are splitting the baby, because I think that's a bad reputation to develop. So if you find that neither side is blameless and that there's some inappropriate activity on both sides, then it's important when you write the decision to make sure that it's so clear that anybody reading the decision says, you know, that was the right result in this particular case. It's when somebody under the pretext of reinstatement without back pay, for example, comes up with a rationale that really is not accurate and therefore is designed with the intent of trying to curry favor by both parties. But judging from the faces that we saw before we went into screen share, we have a pretty sophisticated group of people, and I think they are pretty well aware, as Mary Ellen indicated before and Sudip seconded essentially, is that you basically know in advance what the strength of your case is and what the outcome is apt to be. So let's just scroll down, and I put on the little spotlight because it's important for us to talk about qualifications that arbitrators need to have in order to be able to conduct virtual hearings. I know when Dan Brent and Jim Brown and I was starting with our little study group when COVID started, as a result of the training that Lisa Charles and others did for the National Academy of Arbitrators, I think it's fair to say we were all pretty well lost because we didn't have the special knowledge. We didn't have the special competence. Remember, I guess March of 2020, when the pandemic really hit full swing, we were basically all out of business. And I remember how welcome it was for the National Academy of Arbitrators to provide training, but I have to tell you, I was very intimidated. So now that I know how to use the spotlight, I figured I'd show off and show you that when it comes to specialized knowledge for special cases, if the parties are going to want to have a virtual hearing and the arbitrator does not know how to conduct a virtual hearing, the arbitrator needs to disclose that and maybe decline the case. I know, for example, thank goodness to my son-in-law when COVID started, and I told him the problem of being an arbitrator and conducting virtual hearings and not knowing what I was doing, at least. He said to me, you have to get a more powerful computer and you ought to have 3 monitors. So while I'm sitting here now, I have on my left screen, the left monitor, the code. On the center screen, I have the partial gallery. And on the right screen, I have the folders that contain the code of professional responsibility and the advisory opinions. So sometimes you have to invest to get the qualifications you need if you're going to be conducting virtual hearings. And it's certainly, given where we are now, I think it's fair to say that many parties now prefer the virtual hearings. And I'm curious, from the standpoint of Mary Ellen and Sudip, what your experience has been in terms of the ease of participating and conducting virtual hearings, if you found any resistance to it. Are arbitrators predisposed that they only want to do virtual hearings now because people don't want to waste the time commuting? Do you think you've lost anything in terms of advocacy when there is a virtual hearing because of the remoteness to some extent? I'm curious what your thoughts might be.
Before we get there, we do have a question from the prior issue, but I have a lot of opinions on virtual hearings, so I'm happy to share them all.
Okay.
Any arbitrator that has had a case with me knows my opinions on them. But so the question was, do the advocates believe years of service or other mitigating circumstances should not be considered to determine the proper penalty other than dismissal?
Well, I think that different arbitrators are going to look at things differently. Is there a summary dismissal situation? Is it progressive discipline? Does it make sense to see that somebody might have made a one-time mistake, even if it was serious, and therefore the years of service account for something? I think that many arbitrators would take the position that if someone's been there a long, long time, you don't ignore that. On the other hand, if it's egregious conduct, I think many arbitrators are going to say, I'm sorry, I didn't tell you to do this, and it's outside the pale. Sudip, you have any thoughts?
Yeah, I was going to say, definitely years of service needs to be taken into consideration before making any final determination. But as you said, Bob, depending on the allegation, as long as it's proven, if it's that egregious, even if someone's a 30-year employee in a number of these cases, sadly, they had a great record, no discipline for so long, and then suddenly something happens, they did something really, really bad, and it was proven that they did it. In that type of scenario, the discharge should be upheld just despite their length of service. On the other hand, there are other types of, and that's what I'm talking about, the split the baby sometimes happens, but split the baby happens in other situations too, which is what we were talking about, where some arbitrators are known to always split the baby. And it makes it more difficult for me when I'm prepping a case with someone and I know I'm going to go to arbitration with a certain arbitrator, what the most likely result is going to be it a good case or a bad case, it's probably going to be split. And how am I supposed to explain that to someone who has a good case, especially? But so for someone who has a bad case, I'm not going to be saying that either. So, that's why I felt that it makes, that splitting the baby is not a good idea, or to have a reputation for splitting the baby is not a good idea. And that, on the other hand, of course, length of service should be taken into account, prior disciplinary records should be taken into account, all of that. Mary Ellen?
No, I don't think length of service should be taken into account. I really don't. If it's a bad act, I don't care if somebody's been there 30 years or 5 years or 2 years. I do think mitigating factors should be taken into account. One case that I had, somebody was discharged because he abandoned his position, without notice, but there were mitigating circumstances. His child had been taken to the hospital with a serious injury, and I do think that needs to be taken into consideration. I get very frustrated if somebody does something that's wrong, whether it's, I've had theft cases where people were put back because of length of service, and it was the first time they stole something. That makes no sense to me. So if there are mitigating factors, yes, I do think those need to be taken into consideration, but no, I don't think length of service should.
Well, really what you're saying
Coming from
is,
the management side, I guess no one's surprised to hear me say that.
no, but really what you're saying is if there's egregious conduct of some sort, somebody decks the supervisor, someone steals something. In the airline industry, for example, if you steal a miniature bottle of liquor and you happen to be a flight attendant, it doesn't matter how many years you've been there. Theft is theft.
Right.
That's it. In fact, my memory is that many of the unions wouldn't even pursue it to arbitration because nobody wants to be working amongst somebody who's inclined to take other people's property. But there are different industries where theft becomes a real issue. In any event, I'm looking at the clock and we're like really not making much progress, even though we're going into depth here. So we got to start picking up the pace a little because we do want to cover some things.
Let me answer your question.
Let's
about
do the virtual hearings.
Virtual. So I am not a fan of virtual hearings. I've never been a fan of virtual hearings. I understand the necessity of them. And I think that it was very important during COVID to do them, because could you imagine the backlog of cases when everybody got back if it was not used? But I think people, not arbitrators, everybody has become too reliant on them as an excuse sometimes to schedule more than one in a day, cutting short other arbitrations that may have gone longer than you intended. And I think in terms of advocacy, it's much different virtually. I've run into problems where I don't know if the grievant is being coached in terms of, a cell phone, constantly looking down. And even if you question them and ask them to pan the room, they're not going to show you their cell phone. So those things don't happen when you're in person. I'm not a fan of virtual hearings, and I am trying to have them scheduled more and more in person.
Sudip, any thoughts?
I like virtual hearings. We're doing this virtually today. We could do it in person, and that would be great too. And I like in-person hearings as well. I have nothing against virtual hearings, but there are times where one of the parties or the arbitrator is not well versed with the technology, and then that definitely could be a problem. I have a case that's currently on, and that's been adjourned a number of times where I'm trying to resolve it, because I want to try to avoid a virtual hearing with this particular arbitrator. And because I know that it's going to be tougher and slower. And in that scenario, when we have, if we have to go forward, I'm going to be insisting on going forward in person. So this case is not with you, Mary Ellen. You would have been happy with this, because I would also be saying, no, this case has to be in person, just because the arbitrator is not well-versed enough to do it. And the one issue I do have with virtual hearings, not issue, but first of all, I know many people have the issue with, okay, how can I cross-examine a witness virtually? There's going to be a credibility issue. How can you really determine it if you're not in the room looking at the whites of their eyes? I, like some other arbitrators, don't think you have to be in the room to completely determine credibility. I thought that initially when the virtual platform started due to COVID, I was completely against it, because I didn't know how. It's the first time I heard of Zoom. I had to do it. But after doing it, and 3 years down the line, some cases are better for me to do on Zoom and some aren't. It just depends on the case. The one thing, practically speaking, I don't like is some arbitrators have very rigorous pre-hearing schedule for submitting documents and evidence prior to the hearing beginning. In person, a lot of times it would be the morning of, you show up and then you exchange exhibits, mark them there, do it. And now, to some extent, it's good to exchange exhibits before the hearing starts, to confer with the opposing counsel and figure out joint exhibits to save time during the actual hearing. But on the other hand, some arbitrators want everything to be sent in, even if it's not a joint exhibit, and not agreed to, at least marked, but not actually in evidence. That I don't like, because sometimes I don't want to give, there's not supposed to be much surprise in arbitration, but as advocates, we all know the element of surprise is useful when you're cross-examining a witness, and you don't want the other side to know and give them everything you have prior to the hearing, because then the other side will be prepared for every question that you have. And so I don't like the fact that for a while all the arbitrators were asking me to provide everything in advance, just for the sake of the hearing going smoothly. And so I've noticed that some of the advocates on the other side just ignore what the arbitrator wants to be sent in advance, and they keep these exhibits. And on the day during the hearing, they go, I have a document here, and I'll email it to you now if you need to see it. And so, I mean, that's my only issue with virtual, the document sharing in advance. Otherwise, I'm not worried about credibility. There's issues, of course, with some people don't have the technology, and in that sense, definitely we should be doing this in person. There's advisory opinion on that we could go into later, Bob, but that's my 2 cents on virtual.
I will say that, oh, go ahead, Marielle.
I was gonna say, I do have one question, and I guess I would throw it out to everybody. What if the parties both want the hearing to be in person, but the arbitrator does not? And they
So
want it to be
that's
virtual?
advisory opinion 26, which we can go to now if you'd like. I can put it up on the screen. Seems as natural as anything. Let's see if we can do that.
But this is when both parties
is.
want it and the arbitrator does not.
No, I understand. And you'll see from advisory opinion number 26 that is covered in part, and I've put it up on the screen. If an arbitrator is not willing to go to an in-person hearing, then the arbitrator has an obligation to disclose that in advance. If I know when I don't care, I'll go to an in-person hearing, I'll do it virtually. It doesn't matter to me, except I do prefer in the summer season if I can get to the beach late in the day. So I guess in that respect, maybe in the summer, at least semi-facetiously, it's nice to do the virtual hearing. But you'll notice from opinion number 26. And if one thing that we are able to convey in today's panel, remember that not only do you have the code and the little riddle with the parachute, but there are the advisory opinions. There's tremendous information contained in the advisory opinion. So in essence, you'll notice that this was developed when the pandemic started. And the question was, what do you do in terms of one side wants the virtual hearing, the other side doesn't want the arbitrator. From my standpoint, I'll go during the pandemic. I had a case in Wyoming. I made 2 round trips to Wyoming. I didn't care. If somebody wants to have a hearing in the city, it's not that big a deal. On the other hand, there are parties who prefer it. So usually in the date offer letter, I indicate to the parties, and I think this is good practice. I can easily offer a virtual hearing to you at no additional cost to the parties, if the parties prefer. And I'm also able to offer an in-person hearing. But if it's out of town, then I always point out, consistent with, I think it's part 2K of the code having to do with fees and expenses, that there will be some extra costs associated with that in terms of overnight, if it's travel time, hotels, airline tickets, that sort of thing. And then it's up to the parties, whatever the parties prefer, it's fine. But you'll notice in opinion 26 that it acknowledges that this is a situation that was evolving, that there was a pandemic, and that the arbitrator still had an obligation to provide a full and fair hearing, and there was some discretion. What we think will evolve over time is that parties are going to now, as they're renegotiating contracts, probably put in some reference, perhaps in the grievance procedure section or somewhere else in the collective bargaining agreement, how they want virtual hearings to be handled. And it would seem to me that as time goes on, it's more likely that we'll see more and more provisions like that. And that makes sense, because then you're not subject to the discretion as much of the arbitrator. It's up to the parties to really define how they want to go forward. So someone like Mary Ellen at the negotiation table could say, look, we're going to put something in our contract where the presumption is that we're going to have an in-person hearing unless there is some extraordinary circumstance or something along those lines. So I think that makes sense.
How you doing?
Wait. I heard some back chatter. That's okay. Presumably the person put on mute.
Touch Vegas.
All right. Whoever's talking, please mute your
Sticking around, or you
microphone.
going away?
No.
Sudip,
Okay.
any additional comments?
Yeah, first thing, for those of you looking for CLE credit, it's been 30 minutes. And the first code is EBG-220. So anyone who's looking for CLE credits, please write this down. And you'll need this to put this in your affirmation. It's EBG-220.
All right. So now let's get back. And we're trying to monitor the time sequence, because you can see we can spend an awful lot of time going into these different things. I want to spend a moment on part 1 of the code, C2, having to do with the advertising and soliciting. You'll notice in opinion number 24, which deals with this, that it never really defines soliciting. And the key is that if an arbitrator is looking to be more visible as a part of competence, will take you so far and it's necessary, but you also need some visibility, presumably. And the key takeaway from opinion number 24 is that when you're making efforts to get known, it's important that you make efforts to both parties. Obviously, you have to be truthful, but the theme throughout these provisions is to make sure that it's not geared only to one side, that it should be geared to 2 sides. What gets interesting when you really delve into opinion 24 is, for example, if you look under number 4, you'll see that it's okay to furnish gifts and meals and tickets for sporting events if you're doing it to both sides, it appears. So for example, and this has an impact on newer arbitrators because, for example, suppose an arbitrator has access to season's tickets to the Jets, although now with the Jets being so pitiful, I don't know if anybody would want to go. But assuming they had a relatively decent team, and you invite someone from the union side and someone from the employer side, and you go to a game and you make an afternoon of it, is that ethical? Well, it's geared to both sides. It's more than nominal value, but perhaps that's okay. And as long as both sides are there, it would appear if you read advisory opinion number 24, maybe that's okay. What about if you go to a bar association retreat for a weekend, which, for example, the New York State Bar Association typically has a fall section meeting, I believe, and it's usually at a facility where there's a golf course. Now, some people like to play golf. Suppose that you set up a foursome and you have a union person on it, an employer person on it, and I don't know, somebody else, and the arbitrator. Now, how does that affect a hearing if you go forward and you have a hearing? Do you have an obligation to disclose that you played golf together? So you can see where opinion number 24 can be linked to the disclosure provision that we're going to get to in a moment. Any comments, Sudip or Mary Ellen, about soliciting? I know you've probably gone to professional meetings. I think it's always interesting to hear an honest response from advocates, what it's like when you perceive that arbitrators being a little aggressive in terms of saying hello to you, because they're not looking to really say hello as much as to hope that they get some work from you. So, Deep, you ever have that happen?
Well, I think it's okay in general, but if there's a pending case going on, I think you got to keep your distance a little bit, because if there's a pending case, and even if it's a professional association and I'm having a drink with an arbitrator at the professional association, and we don't even talk about the case, but it's a pending case. If the other side found out, even if we didn't do anything wrong, there might be an appearance of us possibly discussing that matter, even though we didn't, and we're professionals and we've been doing this for years. And so if there's a pending case, I think that's important. Then I think you shouldn't. I don't know, Bob, what you think about, like, if you go to these professional, it could be a Lera event, for example, where there's management and union side and arbitrators all together. Is it okay for you to buy a drink can you buy me a drink at one of these? Is that okay?
I wouldn't. I just don't think it's a good practice. I don't think it creates the proper appearance. It could be misconstrued. I think you really have to recognize that what we do for a living, there's a sensitivity to it. And although you develop, and the code recognizes that you develop personal relationships, professional relationships, you have to be mindful of these things. That's one of the disappointments from my standpoint about the code, that it is not read more often. I find I read it, several times a year because of, presentations on panels like this. Every single time I read it, I learn something. I've been reading it for years and years and years. I happened to pull out a paper I wrote for Gene McKelvey at Cornell when I was a senior. And there at the end of the paper was a whole discussion about a provision of the code. And so I've been reading this code since at least 1972, which I hate to admit is over 50 years. And yet every single time I read it, there's something new to be learned. And so I think with your example, Sudip, it's probably not wise. And I think sometimes it's important to flip these things. If I bought a drink for Sudip, for example, then Sudip might wonder, what am I doing for the other side? Sometimes it's important to flip these things. And so I don't think it would be good practice. I think it's a bad appearance. And I don't know, other people may have different opinions. That's a nice thing about the ethical conversation, is we don't always all have to agree about everything. The importance is to see these issues and at least be sensitive to them, and at least to know where you can go to get more information. There's no reason to agonize over things where there have been very bright people starting back in 1951, when the code was initially developed, that have given an awful lot of thought to this, and might as well piggyback and benefit from that. I do
I have never,
want to, Mary Ellen?
I can honestly say I've never felt that any arbitrator has solicited me directly for business. I think you're all very professional and ethical. But I do have a question. I guess I have a lot of questions. What about an arbitrator soliciting on behalf of one of their mentees? Is
Okay,
that,
so that's perfect. Perfect
is that
segue.
appropriate?
Perfect segue. So let's look at part 1, C4, where it says an experienced arbitrator should cooperate in the training of new arbitrators. And let me put that up for you. It should be here. What does that mean? Are you able to, for example, invite somebody, a new arbitrator, to a Zoom where, here we are, where the mentee or the aspiring arbitrator is not interfering at all with the hearing, because the person may not even have a visibility other than a phone number. The person is able to sit there and learn how to make rulings, or at least learn from that particular arbitrator. And therefore, the experienced arbitrator is cooperating in the training of new arbitrators, as contrasted with a discharge case. Now you invite a complete stranger into the hearing, and even if you got advance permission from the parties, the representatives, maybe the employee who's been terminated doesn't really want a complete stranger other than the arbitrator to be listening to all that. So I think it becomes very interesting in terms of this notion of training new arbitrators. There are training programs. I remember one that was back in 1987 that Cornell and Hofstra Law School and the AAA ran to try to ease the entry into the field of arbitrators from underrepresented groups. And I remember there was an effort made in that program to try to get some of the parties to at least give some of the newer arbitrators who completed this program that lasted over a year, to at least for some relatively routine cases, not necessarily discharge, but 1-2 day suspension, something like that. That kind of effort has been continuing now till the present time. Some are more successful than others. We have the Scheinman Institute at the ILR School at Cornell that has been participating in that and making efforts. But it's a very difficult field to enter. And to suggest to anybody that it's going to be a cakewalk would, I think, be misleading. But for an arbitrator to start pressuring parties or trying to persuade them to use new arbitrators, I think it's a delicate question. I think if parties call up and say, we need a quick hearing, and you don't have time for a quick hearing, I don't think, if you have a relationship with the parties and you have a conference call, I don't think it's inappropriate or unethical for that arbitrator to say, look, I can offer you a date, 4 months out, 5 months out, but if you want someone to do it sooner, I've been working with this newer arbitrator who I have confidence in. You might want to consider using that person, but I want to tell you, I won't be offended if you don't use the person, but I just want to give you an option. I don't think that would be problematic. Would you feel uncomfortable with that, Mary Ellen?
No, I probably would not feel uncomfortable with that if they recommended someone who they knew had immediate availability. But, I guess what I was talking about was every professional get together, somebody saying, oh, you really should use so-and-so, give so-and-so a try. And then if you don't,
is there an adverse inference then? That's essentially what you're saying. I have a good memory, and I remember that I recommended someone, you haven't used the person, and then I think we're probably more sophisticated than that, and that people are just making a good faith effort. Dick Edelman, for example, for years has been working very, very effectively, and I think very efficiently, trying to introduce newer arbitrators into the field. I think that's a very important function. And I think Dick and other people should be commended for that. But I think it is a sensitive issue with advocates, and you just have to walk that fine line.
And one of the issues, and now this isn't ethical, but I'll just share it. One of the issues that comes up is when it's a new arbitrator and you recommend to your client, this is a new arbitrator, I really would like to give this person a shot. And they say, okay, no decisions from this person? No. Okay, if you're confident that they're going to be a good arbitrator, that's fine with me. But if it goes wrong, that's on you. You know, so sometimes not knowing the arbitrator is hard to get the client to agree to select them.
I think that's one thing that maybe the arbitrators sometimes are not as sensitive about the difficulty that attorneys have to build up a practice, to attract clients, to retain clients, and therefore it's hard sometimes for an experienced attorney or a newer attorney to take a shot on someone sight unseen, basically, because they don't want their client to be disappointed. It's one thing if you lose a case and it's to an experienced arbitrator, then I think what you can say to the client is, look, we gave it our best shot, but this is an experienced arbitrator who's had many cases, and therefore we lost this case. It's the way things go. But I think if you say there's a brand new arbitrator who only had 3 cases before, that probably makes the relationship between the client and the advocate a little bit more difficult. Is that fair to say, Muriel?
100%.
Yeah. Sudip, any thoughts?
Personally,
not?
I like, you know, I like the old guard, but I do like to give a chance to the new guard as much as I can. And I like to, of course, you know, it's nice to know and have experience with a certain arbitrator because you know what you're getting, and you, with someone new, you don't know what you're getting. But I still like to try. But the thing is, both sides have to agree. So there's not just me, and it is. And I agree with you, Bob. It's really difficult for new arbitrators to get chosen for both sides to agree. And after all these years, I mostly see the same faces after 20 years for me. And it's rare to see a new face. We're trying, and it happens. So it's really hard to establish yourself in this field, I think.
Let's switch to part 2B, required disclosures. That's a very important ethical issue for arbitrators. What's interesting about the duty to disclose is that the standards are not always clear. You can use, from a legal standpoint, a presumption of bias standard, which would require less disclosure, or an inference of bias or an appearance of bias standard, which would require much broader disclosure. What gets interesting when it comes to disclosure is if you over disclose, then a party looking to delay an arbitration proceeding can be given a pretext to say, well, let's get another arbitrator. It may take 3 or 4 months. So that can be problematic. If you under-disclose, then the risk is that you could be ending your career very early, because if you under-disclose something that's important and a party moves to vacate a decision for failure to disclose something, given the tightness of our community, it may be very difficult to overcome that. I seem to recall, and I won't mention any names, many, many years ago, I think it would have been probably in the 80s, there was an arbitrator who failed to disclose something. And that was pretty much the last time many of us saw that arbitrator. So we're very fortunate that in our field, you don't hear about very many ethical lapses. Occasionally, I mean, you could search, there was a celebrated case with improper interaction between an advocate and a member of a Railway Labor Act panel, a system board, I believe it was, and up in Alaska, and involved the railroad industry. And that did not go well for any of the participants, because it was pretty egregious conduct, going out for drinks together, excluding the other member of the panel, things of that nature. So you can go back for the source of the disclosure responsibilities to the Commonwealth Coatings case out of the United States Supreme Court, which I think might have been like 1968 or so. And then you have J.P. Stevens versus Ritex Corporation out of the New York State Court of Appeals. I believe that was a 4-3 decision. And that was, I believe, in 1973. But you'll see that most of the cases involving disclosure are not from the labor field. They're from commercial arbitration. And that's where we have the source of the various rules. But those are the disclosures. Have either of you had experiences where either someone disclosed and you had to make a determination about whether that was important enough to have a recusal, or where you found out afterwards that someone had not disclosed something? I don't know if that would have ever come up, because most arbitrators now are pretty sensitive to the notion, when you're not sure, disclose, disclose, disclose. Sort of like real estate with location, location, location.
Bob, I've had some over the few years that I've been practicing, maybe 2 or 3 times, where I felt like, oh, I didn't know that, for example, the arbitrator just happened to be classmates with the employer attorney, years ago. Now, do they have to disclose that? I don't know, Bob. What do you think? That they were classmates back in the 80s or something like that?
Yeah, actually, there is an advisory opinion, and let me see if I can, give me a second to pull it up, but I'll talk while I'm doing that. It's advisory opinion number 25, and that does deal with the issue of personal relationships. So let's see if we can pull this up here. Bear with me for a second. That's 24, which we already covered. So let's go to the next one, 25. And for example, the issue becomes, do you have to disclose that you had someone as a former student? Here we go. Duty to disclose. So we have the different provisions that we're talking about, also having to do with personal relationships, which we already spoke about. And the question is, do you have to disclose that there was a student-teacher relationship? There are people who've been professors for many years. You'll see student-teacher relationship. That doesn't create necessarily standing alone an obligation to disclose, but if there was a closer relationship, for example, the professor at a law school had a student who was the research assistant and therefore developed a closer relationship, or the research assistant was helping do preliminary work on a law review article. There, it's not just the passing student-teacher relationship, there's something more. So if it's student relationship plus, then there's more of an obligation to disclose. And when you get to the disclosure issues, it really has to do, to me, with this notion of informed consent. You know, if you go into a doctor's office, the doctor can't come up to you and just give you an injection without getting consent, without getting permission. We call that a battery. But if the doctor says, look, it's flu season, I want to give you a flu shot, is it okay with you? And you say, sure, that's fine, I appreciate it. That's perfectly appropriate. That's informed consent. So it's the same thing here with the disclosures. When in doubt, from a neutral standpoint, and I think also the expectation of the parties would be that there ought to be a disclosure. And then the option shifts to the advocates. Is it okay or not? Remember, disclosure is not disqualification. Just because you disclose something doesn't mean you're disqualified. It just means that you want the parties to be aware of something. And I think that's one of the ways that we ensure that the arbitration field does adhere to high ethical standards, because if you're not sure, it's not a crime to disclose something. The problem is if you're a brand new arbitrator, because if you're a brand new arbitrator, you've worked very hard to meet parties, to get your technical competence, to get the visibility, and you're happy to have a case. Now, all of a sudden you walk in and you realize, gee, you know, I probably have to disclose this. How's the other party going to think? And so it's not so simple, but when in doubt, disclose. And notice the standard here. It would be student teacher, that's okay. How about speaking at different types of organizations, like speaking here tonight? I'm on a panel with Sudip and with Mary Ellen. I go into a hearing somewhere down the road and one of them is present. Do I have to say something? Do I have to raise doubts in the minds of the other people. This is all open in front of 50 people or whatever number of people are in attendance. It's not like it's concealed. It's for professional development. So there's nothing untoward about it. And yet, if you were on the other side, are you entitled to know that people in this field interact with each other at different organizations? So if you read this opinion, you'll see that opinion number 25 is somewhat lenient about it, but you would expect it to be, because who drafted it? Arbitrators. So it's important to remember that. It's also important to remember, for example, that the chairman of the committee for the code was Bill Simpkin, who had been the director of director of the Federal Mediation and Conciliation Service. So you'll see that the code is favorably disposed to mediation in many respects. All right, any other comments on this? Otherwise, we'll plow forward because it's 7 o'clock. Sudip, do you have to give another code? It's another half hour. Looking out for everyone's ethics credits. Yes, no?
Excuse me, not yet. 5 more minutes.
Okay, 5 more minutes. We'll keep going then.
So Bob,
Mary Ellen?
I personally, I think most arbitrators disclose everything, and I appreciate that. So I never personally experienced that. I did have, I mean, on my side, I did have one occasion where an arbitrator had solicited the employer for a summer position for the arbitrator's child, which was given. It was, I can't recall if it was paid or not. It was an internship. I don't recall. But it was not just, the arbitrator did not disclose that to the union. And when the union found out about that, they were not pleased.
You know, one of the things that I've experienced is that usually the parties appreciate the disclosure. I mean, I had that recently out of town. I was at a hearing. I heard a name of someone who was not at the hearing mentioned. It was an unusual name, the first name. And it sort of jarred a memory that I had that, gee, I think people we know, their son may work for this company. But I sat there because I wasn't sure. And then a few minutes later, the last name was mentioned, and I immediately went out into the hallway. I said, look, I didn't know anything about this, but I recognize that name. I haven't seen the person probably in 10 years, but I want you to be aware of it. Mm-hmm. And the advocates looked at me like I was on Mars or something. Like, why are you telling us this? This person is not going to be participating in the hearing. The name was mentioned tangentially, and that was it. And then they looked at me and they said, thank you so much for disclosing it. We really appreciate it. So if you're not sure you disclose, what's the worst that could happen?
Yeah, I agree.
You walk away from a hearing.
Wrong. I don't think you can go wrong with disclosing, but because that particular arbitrator in that case did not, the union refused to use him going forward. Ooh, her, him, her.
Okay, right. Sounds good. All right, let's move forward. And I'm watching the clock because it's a little after 7. So I want to make sure that we can cover as much as possible and be accurate in terms of our representation for CLE credits, what we're covering. So take a look at privacy of arbitration. And this, I think we should tie it into cybersecurity now, because that's an important issue now that we're so intertwined with computers.
Bob, since we're starting a new topic, I think
okay,
it's a good time to do the CLE.
Sounds good.
The code. So the second code is LER-123. That's LER-123.
I'm sorry, is that E as in Edward?
Yes.
Thank you.
Okay, good. By the way, is anybody monitoring the chat in case there are any questions coming in?
I am.
Okay, thank you. So let's take a look at privacy of arbitration, cybersecurity. I don't think it would make, I think arbitrators need to be sensitive to the fact that the process is in fact a private process. Shouldn't be talking about cases sitting next to someone on the subway, if it's traveling, you don't know who's there. Probably not a good idea to be bringing your laptop into Starbucks and having coffee while you're drafting a decision. I think these are all the types of things that we need to be sensitive to. If you're sitting on in an airplane and you're going someplace and you bring along a transcript, is it okay to read the transcript on the plane? Probably, but I wouldn't leave it lying around if you stand up for a minute or two where anybody can look at the cover page of the transcript and see who's involved with it. But that involves just appropriate discretion. Publishing decisions. There's a whole format for publishing decisions where you have to get permission from the parties, but then the question arises, suppose the parties say no, and the arbitrator is upset. So that can be an issue. But the whole issue of privacy takes on special meaning. Any comments about that, Sudip or Mary Ellen?
The only thing that comes to mind in the virtual context is prior to the virtual hearings, it would be, arbitration, usually the door would be closed and that would be the privacy. If you want to sequester a witness, they go outside and they sit in the hallway. That would be the privacy. If anyone from the public or another attorney that the grievant may have, if they didn't have permission to come in, they didn't have the permission to go, so you have the privacy. Now with virtual hearings, I don't know what your opinions on, like right now when we started this CLE program, I clicked on record and so I'm not an expert on cybersecurity, on hacking. If someone could record and I don't know that that's happening. These are, as you said, supposed to be private, and maybe an arbitrator maybe it's good for an arbitrator to record the hearing so it's he could go back, or she, and get an accurate when they're writing their opinion, to get the accurate quote from whatever the testimony was. So I don't know how that plays into it, but it just, came across my mind about the virtual and the recording of these hearings. Or most arbitrators don't record, they say, but I don't know if I could get it.
I think it's actually riskier if they do record, because then I think that could be accessible,
Yeah, I agree with that. That's exactly my
but I think when the actual hearing is going on, at least all the arbitrators that I've appeared before are very careful to make sure only the appropriate parties are there and present, and some arbitrators will have the grievant scan the room with their computer or their phone to make sure no one else is present. But I do think it's a risk. Another reason why I probably don't like virtual, that somebody could join somehow that shouldn't be there.
Yeah, those are the things you have to be sensitive to. Let's shift, again, I'm trying to make sure we cover some materials. Let's talk a little bit about mediation by an arbitrator. The arbitrators selected to be an arbitrator, not to be a mediator. There are people who have very strong opinions about this. There are some arbitrators who are absolutely adamant and will say, I'm not here as a mediator. You didn't tell me in advance you wanted a mediator. You want to try and settle the case. That's why they made hallways. That's why they made breakout rooms. We can easily shift the advocates and the people they need to have with them into a breakout room. Leave me alone. I don't want to do that. Perfectly ethical for an arbitrator to do that. Now, if up front the parties say, look, we're going to want you to mediate. Tell us if you're comfortable doing that. If you're not, then we're going to probably get another arbitrator. That's fine also. Now, what about if the arbitrator is there and as an arbitrator, wasn't brought in as a mediator? Can the arbitrator be converted from an arbitrator to a mediator? How do you do that? If you look at the code, and I'll highlight it with my little spotlight here, you'll see the requirement for advance notice. And you'll see that sometimes the arbitrator can accept or reject it. But what's interesting to me is that it's permissible for the arbitrator. And I think this is the most interesting, one of the most interesting parts of the entire code. If you look at C, you'll see that the arbitrator is able to suggest mediation, and yet it's conditioned. You're not allowed to put improper pressure, but how do you, and you're supposed to try to discern if the parties want you to mediate. How do you do that? And what do you say? And what are the ground rules if everybody wants to have mediation? So it seems to me that the arbitrator can ask the parties, look, you want me to mediate this case? If you want me to, I'm fine. If you want me to, we'll set up the appropriate ground rules that you feel comfortable with. And if you don't want to, that's fine with me. And I usually try to make it a little bit amusing. Jay's heard me say this on occasion. You know, if you don't settle, my wife is happy because we'll get study days out of the deal. And usually people chuckle a little, but it's a way to try to soften the question and make it easy for one or both advocates to say, let's just have the straight arbitration hearing. What becomes more challenging, and particularly I think for newer arbitrators, is if you start mediating, what's the difference between trying to persuade the parties and putting too much pressure on the parties? So if you look at the code very carefully, the most important word there to me, and let's see if I can put it here, is the word insist. The word insist does not specifically appear, but in essence, if you say to the parties, look, we're going to do the mediation. You've agreed to this. There wasn't any undue pressure. The ground rules will be that it's like Etch-a-Sketch. If the mediation doesn't work, we just shake it up. We forget everything we talked about in the mediation. But if I hear you say at any point, I insist that we have the hearing to go forward. And to me, that's the key word, is to say, I insist we have the hearing. Then I know it's not gamesmanship, because sometimes what happens is the parties will say, oh, we're wasting our time. Let's just have the hearing. And in reality, that's just part of the give and take of trying to get to a settlement that's acceptable to that party. So I always set it up in advance. If I hear the word insist, then the mediation ends. Any thoughts? Mary Ellen,
I've
do you feel
experienced
comfortable with,
all
do you
of
feel
that.
comfortable? I'm sorry?
I said I've experienced all of that. Arbitrators that won't get involved in mediation at all, arbitrators that are very insistent and aggressive about mediation, and then arbitrators that ask, have the parties try to resolve it? Would you like assistance in doing that? So, there's a wide range of how that goes.
Do you have any thoughts about it?
I always appreciate it if I think a case is worth resolving, if the arbitrators assist. I think that's helpful a lot of times for my side, and also helpful for the union side.
Do you have any problem with the arbitrator going arbitrator, mediator, back to arbitrator?
I do. Just recently, I didn't before, but I had one hearing where we tried very hard to resolve it. The grievance was difficult, didn't resolve, and I'll make this fast. And we had offered things, and the decision was one which was identical to what the settlement discussed was, but part of the settlement or part of the decision included mediation, or suggested that was not part of the evidence. The arbitrator had only learned that information through the settlement discussions. It was not brought in during the actual hearing of the case. And first time that ever happened to me, and was a little concerning to me.
Diplomatically described. Sudip, you've gone through this many, many times over the years. Any thoughts?
Yeah, well, my one thought is when you mentioned the Etch-a-Sketch, and you mentioned, and you have mentioned in prior hearings that I've appeared before you, that I think you've said that you wear two hats sometimes. You have the mediation hat, arbitrator hat, you take off one, put on the other, or maybe someone else did. But is that really, realistic after an extensive mediation, a tough one where you go back and forth and you've heard a lot of things? Can it be done? Really? Is that practical, or is there a line where an arbitrator should basically say, look, I've tried to resolve this. I've heard, you should get if you're not going to settle, you should have a separate arbitrator at some point.
Certainly, that's something that I know I've said on occasion, rarely. I've been trained this way starting when I was in college, because some of the professors I had would do this type of thing and we talked about it. But some people may feel it's unrealistic. I've never really had a problem with it that I know of, but that's a judgment question. And that's why I think it's so unfair to view arbitrators who say, look, I'm not going to mediate. And that's just the school of thought I belong to. And for them to be criticized, I think it's a very valid approach to take. To say, look, you want to settle it, go in the hallway, leave me out of this. I'm here as an arbitrator. I don't want to know about all this other stuff. And yet other times when you do get converted from arbitrator to mediator, oftentimes you can be very helpful to the parties. You can get resolutions that you could never, ever do in an arbitration decision. It wouldn't be appropriate. And the parties are not able to do it for whatever reason on their own. So
There's a comment, Bob, in the chat that says, once an arbitrator begins to mediate, she must disqualify self from continuing to arbitrate.
there are people who take that view, and I'm not going to disagree with that in terms of it being a valid approach to take, but I don't think it's the only approach to take. And so long as the parties are informed in advance of what the ground rules are, and the grievant is informed of this is how we're going to do it, and everybody's on board, then that's fine too. But I don't think that the code of ethics in some instances is an all or nothing situation. That's why there's discretion involved, and it becomes very important to know how to handle these things. But that also, the parties control the process. It's not for the arbitrator to make these decisions. And if either party says after a mediation effort, you know, it'd be better if we get a different arbitrator, the arbitrator has to acquiesce to that without any hesitancy whatsoever. That's my approach. And again, I think reasonable people can differ, and that's fine. So let's move on. I think it's important for us to spend a moment on consent awards. Consent awards sometimes do show up. You'll see under use of assistants. It's okay to use an assistant without disclosing it so long as it's just preliminary drafting. That's the key. If the arbitrator is using someone for preliminary drafting, the arbitrator's decision is the arbitrator's, and it's not delegated to anybody else. That's use of assistants. Consent awards. Fortunately, sometimes we are able to work out, particularly when there is this use of Part 2F with mediation, and you end up with a consent award sometimes. But the key is here, the standard, which I'm highlighting: proper, fair, sound, and lawful. That's very important, because the arbitrator should not be signing a decision that is improper, unfair, unsound, and unlawful. So the arbitrator has to discern from the parties that enough information to make that type of an intelligent assessment of the situation. There are two different types of consent awards: disclosed and undisclosed. The disclosed would actually say consent award on the face of the decision. When there is a consent award that's disclosed, I like to say language in the decision, something like, in accordance with Part 2I of the Code of Professional Responsibility for Arbitrators of Labor Management Disputes, I find that the terms of the consent award are proper, fair, sound, and lawful. I think that can be very helpful for the union in terms of any potential duty of fair representation issue before the NLRB. I think it can be helpful for the employer's representative, also going back to any of the people in the organizational chain, to be able to say that, look, this outcome made sense. Even the arbitrator says it was proper, fair, sound, and lawful. Any comments? Otherwise,
Bob,
go ahead.
just one thing. I know we're going out of turn, but I keep on missing the chat. But one of our friends said that for a prior topic, there is a difference between mediation and facilitating a resolution. And I think that's probably right.
Again, it depends upon what the parties and the arbitrator / mediator work out. If the parties give guidance and say, look, we just want you to be a messenger back and forth. We don't want you sitting in the room and trying to persuade a grievant or persuade a director of labor relations to reach a certain outcome. That to me would be facilitating. That's easy. Then you're just the messenger. If the parties want you to sit there and try to establish a relationship with the participants and you're comfortable doing that, that would be mediation and you're going back and forth. So I think that's a very helpful observation to differentiate between facilitating and mediating. But you'll notice that under Part 2F of the code, it's perfectly appropriate for an arbitrator with the consent of the parties to serve as a mediator. And that's why whenever we raise this particular issue with ethics panels, we always get a good response, because it is such a sensitive, delicate topic, but also it's very, very helpful because remember, arbitration, at least some of the schools of thought, say that it's an outgrowth of the collective bargaining process. And therefore you can view arbitration as purely adjudicatory, or you can view it as a part of the process to try to reach a consensus. And different people have different views on that. That's perfectly fine. And that's some of the genius of the code going back to 1951, where they created these types of choices that can be made and tried to give some guidance in terms of best practices. Let's move avoidance of delay. There are different delays that occur. There's the early part with the scheduling. The arbitrator may offer earlier dates and one or both of the advocates are not available or their witnesses are not available. And then of course, there's the post-hearing delay in terms of briefs being filed, transcript being furnished, decisions being written. I think to some extent, this is one of the more challenging parts of the code, because if you have a heavy caseload and you want to do a thorough decision, sometimes that runs up against the clock. And the key is to make sure that the parties are in agreement that if you need a little extra time to write a decision, that would be forthcoming within reason. Any thoughts about delay in arbitration?
I don't have any thoughts on that, because as long as, like you said, we're notified that there might be a delay. But I want to go back 1 second to this consent award. I was distracted for a bit. And sometimes we need a consent award from the union's perspective or employer's perspective, because there's a grievant who's not going to sign a settlement. But on the other hand, so my question is this, okay? I think a consent award, can you really give a consent award that's just and reasonable and fair without hearing any testimony or taking any evidence?
I think it can be done if you trust the parties and they're able to give you a fair description of the case. If it's a disclosed consent award, you can go into the hearing room and say, look, give me some brief opening statements. You can indicate to the people in the hearing room that pleased to indicate that the parties have reached a tentative resolution of this matter. They've asked that the settlement agreement should be incorporated into the terms of a consent award. That's a disclosed consent award. And you make sure that you acquire enough information to make an intelligent judgment. Now, the more challenging one is an undisclosed consent award, where you look at the face of the decision and nobody knows it's actually a deal. And the question is, if it's an undisclosed consent award, it could be collusive. And collusive, that word is not a very positive word. That's bad. So the question is, are there circumstances where the parties have a legitimate reason in wanting an undisclosed consent award, and the arbitrator is able to conclude that it's still proper, fair, sound, and lawful? I'll give you an example. The employer's attorney says, look, we gave advice, Director of Labor Relations, we all gave advice to the operations people about what should be done, and everybody shut us down. We know what the collective bargaining agreement provides, and we need a decision that is supportive of the union's position because we know the union is right. That might provide a basis for an undisclosed consent award. If you're going to do an undisclosed consent award, though, you can't issue the decision the next day. You got to wait a decent interval to camouflage the fact that it's an undisclosed consent award. On the other hand, where it becomes very, very delicate and maybe inappropriate you have a discharge, and the union comes to the employer and the arbitrator and says, look, we don't want this person back. We want you to sustain the discharge. That's probably not going to be proper, fair, sound, and lawful. The problem is, once you're told about this as a neutral, if you walk away from the case and say, oh, look, I can't serve here because if I give a decision for the union, they're going to think I retaliated. That is, if you put the employee back. If you sustain the termination, then everybody thinks you were part of the collusion. So now you recuse yourself, you walk away, and the two attorneys chat with each other and they say, look, that didn't go so well. We're going to have to get another arbitrator, but you know what? We're not going to tell that arbitrator that we want this case, the termination, to be sustained. So the unsuspecting arbitrator comes in, listens to the evidence. The arbitrator is not able to discern that the union advocate is not doing a very thorough job, and therefore the employer wins. That's a problem too. So I don't have a good solution to this one. As a newer arbitrator, walk away from this type of thing. As a more experienced arbitrator, you might be able to say, look, as far as I'm concerned, etch a sketch. I didn't hear anything. Put on your proofs. The chips are going to fall where they fall. Not a very satisfactory one. The more conservative, safer route to take is just to walk away. You might not even want to deal with those types of parties, actually, because certainly the union is not making a very strong effort on behalf of the discharged employee. But you could understand where if the labor relations people and the employer's attorney say, look, we've had a problem with the operations people, we're more concerned about the relationship between the union and the employer and the ongoing relationship between the parties, maybe it would be okay to do an undisclosed consent award. Very fact sensitive. I just want to go through a few things quickly now because I see it's 7:25 and we're very respectful of people's time. So you'll notice that for fees and expenses, that's been a delicate issue for many, many decades. The key is actual time spent when it comes to study time, unless there's a different relationship. For example, if you have a day of hearing, the perception may be that, gee, there was a day of hearing, there are 2 days of study, regardless of actual time spent. You'll notice under the last part of 2K that the parties have a right to essentially get an accounting. And you'll see an arbitrator has to maintain accurate records when it comes to actual time spent for study time. And that's what I do. I take a scrap of paper, I put down the date and the time that I work, and then I convert it into the per diem. For me, I'll have a minimum of 1 day per diem, and then I do it typically in increments of half days. So if I spent a day and a half, it's a day and a half of per diem. If I spend 2 days, it's 2 days. But I have records to support everything. The thing is, I tend to be very conservative, and no one's ever asked me for my little accounting. I have all these records and nobody's ever asked. But better safe than sorry. Any questions on anything in part 2? That's really the meat of the code. Or any observations, either Mary Ellen or Sudip? Okay, we have 3 minutes to go through 3 parts, so 1 minute apart. Responsibilities to administrative agencies. Just very important to remember that the administrative agencies are there for the parties, not for the arbitrators. It's important to be accurate in terms of availability in case there's a problem with that. Can't try to influence the administrative agencies. There used to be a well-known arbitrator who's a very nice person whose practice was to bring donuts to the case managers and to the parties, I think, and used to say that you should start off a hearing with something sweet. And I don't think that that's something that's done anymore. But back in the day, that was something that was common. There were situations, I believe, where the case managers or the tribunal administrators, I think that was their title, arbitrators would go away in the wintertime, for example, to an island on the Caribbean and bring little gifts back for the case managers. That's a no-no. You're not allowed to do that. Pre-hearing conduct. Look at Part B. Let me try and bring that down. See where it says copies of any pre-hearing correspondence between the arbitrator and either party must be made available to both parties. What about subpoenas? One party approaches an arbitrator, wants a subpoena signed. In New York State, under Article 75, an attorney of record can sign a subpoena and doesn't need the arbitrator to do so. But suppose one of the advocates is not an attorney, it's a union rep or a labor relations person. They need a subpoena signed. Do you disclose that to the other side? The way I read the code is that would be a pre-hearing correspondence, and unless the parties have some other arrangement that they both agree to, my practice is the other party ought to know that a subpoena is being signed. You go into a hearing and all of a sudden you find out there's a document that the arbitrator signed. You didn't know anything about it. It was done on an ex parte basis. I think that's a real problem. Well, that takes care of that. In terms of hearing conduct, it's perfectly appropriate for an arbitrator to clarify the record, but the arbitrator ought not to intrude in the presentation of the case by the parties. If the parties want a transcript, that's fine. It's nice to have a transcript sometimes. Problem arises where one side is able to have the transcript. It could be the union. More often it's the employer, but sometimes the union has an ability to pay for a transcript and the other party doesn't have the resources. What happens? What does the arbitrator say? Well, it's nice to get a transcript. On the other hand, if it's not going to be shared in some fashion, oftentimes the party not paying will have access to the transcript without paying. Then it's better practice for the arbitrator to say, look, you know, I take notes oftentimes, I'll take notes, but let's face it, transcript is going to be more accurate. And we talked about recordings, ex parte hearings. That's very important to know about because you're not supposed to have ex parte hearings. I've had, I think, only one formal ex parte hearing in all the years. And there I made sure that after the first day where the party was absent, we got the party on the telephone. Person said, I'm not going to participate. We adjourned that hearing. I said, I want you to have served on that non-participating party by certified mail or whatever, proof that the party was on notice about the hearing. Then the second day came, party didn't appear. The first party had to make out a prima facie case. It comes as no surprise that party ended up winning the case, but it was done by the book, fairly consistent with part 5 C. Plant visits, site visits. Very, very interesting that oftentimes arbitrators and parties don't realize that so long as one party requests a site visit, it should be granted if it's arguably relevant to the case. And so you can take a look at that at your convenience. Sometimes the site visit can be outcome determinative. And lastly, just so that the CLE people looking over us will not be able to complain, post-hearing conduct, perfectly appropriate for an arbitrator to retain jurisdiction for the remedy without the permission of the parties. Also, and I hadn't really focused on this, but in preparing, I did look at it. It's very important that decisions be concise, that they not be unnecessarily lengthy. Sometimes the nature of the case means that you have to write a lengthy decision just to treat the issues properly, but you shouldn't artificially expand it, maybe to justify a larger number of study days or something like that, or to deal with issues that really don't need to be dealt with. Any comments, Sudip or Mary Ellen?
No,
I want to tell you.
Good job. 3 minutes, 3 sections.
I just want to mention, I want to thank Sudip in particular for inviting me to participate. It's been a pleasure to work with both of you. I hope that we were able to convey some valuable information to the attendees. And also, really, if you can remember my little riddle with the parachute, it's important to read the code periodically. That's when it's useful. Sudip, it's all yours.
Thank you for everyone that's attended. I hope you learned something here. It's 7:32. I know everyone has something to do. Happy holidays. And we'll see you in the new year with new programming.
Okay, everybody be well.
You
Thank
too.
you.
Thank
Happy
you.
holidays.
Happy, healthy new year in a world at peace.
Thanks, everybody.
Thank you.
Well, thanks, guys.